of a child. The agreement was for a cap of 15 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
No, Your Honor.
All right, Mr. Vasquez, you may proceed.
Well, Judge, you already know what I'm going to plead for. Salam was 21 when this occurred, when the girl was not yet 17. She was 6 or 7 months shy of 17. It was very stupid and irresponsible and hormonally insane. I don't know if he's been living underneath a rock or what for the last 5 years, but he should know someone that age cannot consent.
Let me ask Mr. Hoffpower, or what I have read in the pre-sentence report, and there's no statements of interested parties, and so the victim or her family, no one responded to this. What I'm reading is that the girl I guess here's my question. I don't see any allegations that this was not consensual. Now, I obviously understand that legally she cannot consent. So I'm not talking about legally, but I'm talking about factually consensual. It appears to me as though it was factually a consensual partying. They actually reached out, the girls, to Mr. Blackwell, if I'm correct. Go see alcohol, want to party, and all the things happened consensually, factually. Am I correct on that?
That's the understanding. Now, if we go by just the defendant's account, which is in the PSI.
But we don't have another account. And so if we don't have another account, then I guess my question is, why are we even talking about, and let me tell you something, Mr. Blackwell, what you did was absolutely stupid. But when we've got a 21-year-old and a 16-year-old, when the 16-year-old's the one that reached out to go party and do these things, do I feel like there needs to be some punishment, some rehabilitation, some better judgment calls? 1000%. Do I feel like I'm going to send this young man to prison for that? I mean, Mr. Hoffpower, is that what you're asking?
Your Honor, we just, with the cap, and all we have, I can't speak to why they did not respond to probation. We were ready for trial. If you remember this case, we brought this to, we were ready to go to trial.
Right.
And so when we notified them about when the sentencing was. Now, the account by the defendant is, there's still no attrition in regards to whether or not that they can't consent, even when he knows she can't consent, he acted like it was what the court's acting like it was. He picked up someone and didn't check with her how old she was. And it seems to me that he's not acting like he did something wrong. It's just, I just picked up a girl off of Instagram and brought him out to party. And I don't see where there's any, acknowledgement of guilt in this. And I believe we're here, he pled guilty.
Well, he pled guilty and could go to prison for 15 years, so that's some acknowledgement, I would think.
Now, also included in this, Judge, is the court has received.
I have that, and I'm going to get to that in just a minute.
As to the other, I can't speak to, we've given them notice to when the hearing is, and they've been called by probation.
Okay.
And that was the plea, was the cap to avoid a trial. So that's what happened. And the state is just leaving it for the court to make that decision. We're not arguing forcefully for prison time. We're just leaving it at the discretion of the court.
I mean, no matter what, Mr. Blackwell now is going to have to register as a sex offender, going to have to go through treatment, all that stuff is going to be out there. And I don't want anyone to think that what I'm saying is that, Mr. Blackwell, that I think what you did was okay in any way, because it's not. I just don't think this is the case and this is the set of facts unless there's something else that I'm missing for some lengthy prison sentence when, you know, we're not talking about a 12 or a 13-year-old. We're talking about someone that was almost legally able to consent, reaching out. And
I think the court needs to know there is one other factor that adds to this, that videos of this act were posted online. So a 16-year-old in sexual acts was posted
Right.
online in this case.
but who did that?
That is
wasn't
something that was to be proven whether or not,
who posted
It was
what,
posted.
and yeah.
but
That's,
it was posted.
I mean, it was a ridiculous situation. It was, I mean, I guess, Mr. Blackwell, tell me how you feel about this.
My defense, I did make some irrational irrational behavior. I should have been more level-headed about the situation.
I mean, you understand that no matter how willing someone is, you are the older person and have to make better decisions. So tell me what's been going on in jail. Looks like we have last year, looks like pretty much every single month, just about, you had some type of write-up. April, May, June, August. August was a bad month. September, November.
Most of my cases, I was talking after the time, or when it was time for me to get up, I ended up oversleeping, so I received verdicts for that.
But if you, you're right, but I mean, if you can't follow rules while you're in custody, that doesn't give me a lot of good feelings about whether you can follow rules if I give you a probation. Does that make sense to you?
It does, so,
That you're coming in front of me. Of course, since you've pled, you haven't been in trouble, so that's a good thing. Knowing that you're going to come in front of me and possibly go to prison for 15 years. I mean, I think I've explained my position and why I have this position. And again, I don't want you to think that I think what you did was okay, because it wasn't. But because of the situation and because of the ages of everyone and because that there is absolutely no evidence that this was factually not consensual, what I'm going to do today, Mr. Blackwell, is I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. But today I'm going to defer all proceedings and place you on probation for a period of 10 years. You are going to pay a $1,000 fine. You're going to follow all of the rules and conditions of probation, which means being on the sex offender caseload. You will have to register as a sex offender. And you will have to, you're not going to be allowed to have social media, at least for some amount of time until I say so. I am also going to order that as a condition of your probation, you enter and successfully complete the cognitive track of the ISF program. That means you're not getting out of jail today, right? You're going to a program that is designed to teach, especially younger people, better ways of thinking and decision making. And I'm hoping that when you do that, you'll get out and you will make obviously better decisions, be successful on this probation, because the opportunity that you're being given today is huge. You actually do not have a felony conviction on your record, and I'm not doing that for you. I want that clear to everyone. The reason I'm giving you a deferred probation is because if you violate that cap of 15, it's off the table. So if you violate your probation, I can sentence you anywhere between 2 years in prison all the way up to 20 years in prison. So this is your chance. I don't want you coming back in here later and saying, well, I need help with this, or I tested positive and now I need help. You need to ask for help ahead of time if you need help with anything. If you're drinking too much, if you're smoking marijuana, I don't know whatever it is. If you need help getting a job, if you need help with where to live, you better ask those things and not get in trouble and then come back and ask me for a chance again, because this is the chance I'm giving you. Do you understand? I do need y'all to do, before you leave, I'm going to hand you a trial court certification that shows this was an agreement I followed, and so you've waived your right to appeal. Y'all did not fill out the sex offender registration paperwork. You're going to need to go over some paperwork before you leave the courtroom today and sign it. Mr. Vasquez will go over that with you. It explains the process of sex offender registration requirements. It's very important that you do that correctly for two reasons. One, it's part of your probation that you have to register as a sex offender. Two, it's the law that you have to register. And if you don't, not only will your probation potentially be revoked, you'll also have another felony offense. It's that serious. So that's to protect the community, so that I feel better about what I've done today and that everybody knows that you're doing what you're supposed to be doing. Do you understand? All right, here's that certification. If y'all will get that other done before he leaves the courtroom, please.
Thank you, Judge.
All right.
Thank you.
Give everybody just a minute to get up here. All right, so are you Trishad Tarrant? And this is 24 DCCR 1217. And Mr. Brewer, will your client waive the formal reading of the indictment?
We will, Your Honor.
Mr.
Cook, by the way.
Mr. Cook, I'm so sorry. There's
Mr. Brewer was the guy that's actually on the
Gotcha.
vacation.
Thank you, Mr. Cook. And Mr. Tarrant, before we get started, I'm going to make sure that we're all on the same page. I know the clerk had you swear in, but said that you didn't answer out loud, so I want to make sure we are all clear, that the record's clear. So the best you can, would you please raise your right hand for me? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. And it looks like in cause number 24-1217, the state has elected to proceed on the lesser included offense of the first-degree felony murder, and that's from May 21st of 2021. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you
Yes,
with?
ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Cook?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right, or not the district attorney, the state's attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement, is that an 8 or a 0? Is it 20?
20 years, Your Honor.
Okay. The pins are, make it a little bit funny.
Could you please get the tune and put an A?
I got, yes, sir.
Makes a
Yes,
little
sir.
bit of difference.
Yes, sir. And so, do you understand if I follow this agreement, you're waiving any right to appeal?
Yes, ma'am.
Also, sir, do you understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Tarrant is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the first-degree felony offense of murder. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That will run consecutive to cause number 16808 out of Van Zant County, Texas. I am going to hand you in just a second the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You are also going to be handed a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Okay.
I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Cook. And it's my understanding that there is a victim impact statement. Is that correct?
Yes, Your Honor.
Okay. Let's do this. If we can, Mr. Lewis, I'm sorry.
Yeah, I was going to submit it to the court, Your Honor.
Oh, okay. I didn't know if somebody was here or if they
They're
wanted to.
watching on Zoom.
Okay.
They're watching the proceeding in communication with them. They are fine with me submitting it.
Okay. Thank you. And did you want to read it out loud for them or just submit it to the court?
I can read it out loud.
Okay.
It's not very long.
Okay. Yes, ma'am. And we'll go off the record.
I wanted to know why this happened. I was extremely sad and just miss him. I felt helpless because I knew I was never going to see him again. I wanted answers. I wanted to hug him. I thought he was only going to be at that facility 3 days and then he was going to be released. We even prepared his room for his arrival, but that day never came because he was murdered. My son was not a rebellious person. He had reconciled with the Lord and was ready to come home.
Thank you, ma'am. Thank y'all. You're free to go back with the bailiff.
Does he get these copies?
Yes, he can have those copies. All right. Thank you.
Here lies an career defendant who's an habitual defendant of theft by taking. His actions has led him to jail, or let's say prison, for 12 years. After receiving his sentence, he immediately insults Judge West. Let's sit back and see how this case plays itself out. Don't forget to subscribe to our channel as we're going to keep dropping great.
Good morning. You are Jimmy Taylor.
Yes, ma'am.
And Mr. Taylor, you were previously in court, entered pleas of true and a motion to revoke your unadjudicated probation. Counts 1, 2, 3, 4, 5, and 6. You pled true to all of those counts. You're on probation. The second-degree felony offense of theft of property with previous convictions with findings that prior offenses were true. You were placed on that probation January 24th of 2024. I have received the pre-sentence report, as well as there was one incident report from the jail, a page that should have been sent to you all, and also Mr. Coleman has also provided a copy of the court's sentencing hearing, a transcript from that original sentencing back on January 23rd of 2024. Has everyone had an opportunity to review all of those things?
We have, Your Honor.
State has, Judge.
Are there any additions or corrections to that updated report?
Not from the defense.
Not from the state, Your Honor. There are a couple of things I'd like to speak to if and when the court would like to hear from you.
Yes, of course. So let me just, there's no agreement in this, correct? This was just open to the court?
That's correct, Your Honor.
Yes, Your Honor.
And, all right, Mr. Rojas, you may proceed.
Thank you, Your Honor. We're going to be asking for the court to continue Mr. Taylor on probation. I know by looking at the PSI on paper, it doesn't look like there's a chance that Mr. Taylor should be given, especially given his criminal history. It looks like his criminal history is all in some way related to drug abuse. If you look at the allegations he pled true to, those are the non-compliance allegations have to do with drugs. And the reason for not complying with the JCDI program, he doesn't come from a wealthy background. He doesn't have a whole lot of affluent friends and family members that can help him out. He had a ride with his brother. His brother had an accident, and that option was not available to him anymore. He indicates to me that he does want help getting off of the drugs, and I'm sure that when Mr. Coleman has a chance to speak, he's going to point out the comments made by the court to this defendant about not wanting to hear about needing more help with drugs or any relapses.
I really don't, because here's the thing, Mr. Johnson. I'm looking back at your original pre-sentence report that when I put you on probation, and I make notations on those reports and make highlights and those types of things. And I'm noting that in that report, you already, before this case, had gone to ISF and SafeP. And then on this probation, I sent you to ISF at the beginning of the probation. Is that correct or no?
I believe parole sent him to ISF.
Yes, ma'am.
So you were on parole.
Yes, ma'am.
I gave you a probation against Mr. Coleman's wishes and really against what looked like I should have. You went to ISF regardless of who. So you've been to ISF twice. Is that correct? You're looking at her. You've gone. Have you been to ISF once or twice?
How many times?
How many times?
Twice in 20 years.
Okay, so you've
I've
been,
been in prison 23 years out of the last 30 years. So I've been doing my time, and
but you
I
keep
haven't had a chance to,
to do what? Because you've been to SafeP, you've been to ISF, and you went to ISF more recently, right?
Yes, ma'am.
Okay.
As soon as I got out, I got it right on probation, and I haven't had a chance to.
You got right on probation. You didn't.
Yes, ma'am.
You
And I
tested.
had to go to Beaumont, which
You
I'm
tested
from,
positive for
Colorado.
cocaine
Yes,
after
I
all of this time, and all the different things that have been given to you, and the opportunity that I gave you back in January of last year. You pled open, just open to me. I could have done anything.
Yes.
I could have sent you to prison for 20 years, 10 years, and I gave you an opportunity. And I said on that day, because Mr. Coleman printed it out for
I know
me.
what you said.
Well,
Ma'am.
so how do I do anything other than what I said?
I mean, the situation. I've got parents. My mother's 90 years old, man. I don't want her to die and I be
Hey,
in prison.
we're not talking about anybody
You
but
know
you
what?
today.
Yeah, I know.
I'm sorry your mom's that old and that you
Yeah.
haven't been around to be with her, but that's whose fault? It's not going to be my fault if you're not there. How about some personal responsibility instead of my mom is old and don't send me to prison?
Judge, what I was saying about this.
Go ahead.
He was warned about not coming back, and the court didn't want to hear about a relapse, but I don't know that this is really a relapse. He never really got the help. On this most recent term of probation with the JCDI, and if transportation is going to be a problem, I know he's already been to SafeP, Judge, but it would be the relapse portion of SafeP would be appropriate, or a whole new term.
Hold on. So if I'm reading this, I want to know when he went to ISF this last time. Parole sent him when, because the way I'm reading is you were released from ISF and started JCDI August 6th of 2024. So I put you on probation in January, and between January and August, you went to ISF last year. Is that correct or no?
Parole sent him to ISF because of additional charge.
Okay. So when was that?
He was in custody in Jefferson County,
Mhm.
and then from custody.
Went straight there.
parole,
So I placed you on probation. You never got out. You went and got help at ISF. Okay. All right. Anything else?
And Judge, if the court, and it seems like the court is not leaning towards probation.
No. No.
I would point out, we understand the range of punishment is up to 20 years, but the bottom line of that range is 2 to 20. And
I still haven't done anything yet, so your response and how you act right now is going to go into what I do.
Yeah, I understand the legislation makes it possible to go all the way up to 20, but it also makes it possible to go down as low as 2. I think we have to look at each case for the facts, and the underlying offense was a theft at the Dollar General, I think, or Family Dollar, I think it was about $100 worth of merchandise. I would ask the court to consider something at the lower end of the range, maybe 2 to 5. Just because we can drop the hammer on them, that doesn't necessarily mean that we should. And that's what we're asking the court to do. Probation is not going to be an option.
Thank you. Mr. Coleman.
I'll keep it brief. The defendant has earned every bit of a 15-year sentence in prison. That's what I asked for originally. You placed on deferred. That's what I'm asking for today. 3 things I'd like to quickly point out, Your Honor. Looking at the defendant's version in the updated PSI, he says that when he was placed on in the JCDI program, that he believes it was an attempt to set him up for failure, demonstrating a lack of acceptance of his own responsibility. The resources and time that have been dedicated to this defendant, limited resources, mind you, could have been redirected to someone who is more amenable to being rehabilitated. Lastly, you got his full criminal history there in the original PSI. And I provided you with the transcript from the sentencing just to remind the court. I know you see a lot of defendants, but just to remind the court that you essentially told him up front this was essentially a zero tolerance probation.
And I do appreciate that because I do see a lot and I don't remember it all. But Mr. Taylor, do you have anything you want to say?
Yes, ma'am. Been through a lot of things in my life, people dying in my family and other things, drugs. But, I think, that I could do better if I had a chance, proper opportunity, ma'am. And I did a lot of time. I've done my time.
You have.
I don't think just putting me in prison I think I need a chance. I really do.
It doesn't make any sense because you're saying, you've done a lot of time. And at some point, you either say, I don't like prison and I want to do better.
That's what I want, man.
But you didn't take advantage of the opportunities you were given. You're saying you want help. And we gave you help, or parole gave you help. So you didn't even get out on my probation yet. You had ISF, a reminder of the tools that you had a long time ago. You had those things, and you got out, and you didn't take advantage of the opportunity that I told you. You better take advantage of it because you're not going to get it again. You're saying the same things that you said. Please just give me another chance. I'm going to do better. Please send me to ISF or a safety. It's all the same thing that you're saying, and no one is setting anybody up for failure. I can hang on.
To the JCDI. I had back surgery.
So what you're telling me is when did you have back surgery?
8 years ago.
Okay.
But they only did half.
Listen.
I'm not making
If you're throwing out to me that you had back surgery 8 years ago, then you are digging for everything you possibly can, and we're done with all that. I'm going to find that you previously entered your pleas are true to counts 1 through 6 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. I'm going to sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you trial court certification that shows this was not an agreement. You do have some limited rights to appeal. You can talk to Mr. Rojas about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you.
In one of the most dramatic courtroom moments, a repeat offender stood before the judge after repeatedly violating probation and testing positive for cocaine. Despite years of opportunities, treatment programs, and repeated warnings, the defendant failed to change his behavior. The judge reminded him that she had already given him a second chance when many believed he should have gone to prison. After reviewing his criminal history and hearing both sides, she sentenced him to 12 years in prison. But the biggest surprise came after the sentence was announced. As the defendant walked away, he made a disrespectful remark. The judge immediately called him back, reminding him that she still had legal authority over the case and could increase his punishment for contemptuous behavior. Her powerful warning made it clear that respect for the court is not optional. This intense courtroom exchange shows how quickly one careless decision can make an already difficult situation even worse.